attention and you shall be heard. God save the United States, great state of Florida, this honorable court.
Please be seated. We have one case today, Antonio Melton against the state of Florida. We will hear from Mr. Melton's counsel.
With the court's permission, I'll save 5 minutes for rebuttal. May it please the court. We are here upon the appellant's contention that the circuit court erred below by not considering the doctrines of the law of the case and waiver and granting the state's motion to disqualify me from representing Mr. Melton below. And alternatively, the court erred by not permitting me to represent Mr. Melton pro bono in the court below with the success of 3850 that we had filed in this case.
Has the state taken a position on your representing him here?
I guess not directly, Judge, as far as once we had filed the appeal, but the appeal, the very essence of the appeal that we sought was my ability to represent Mr. Melton, but I don't believe anything's been specifically filed as far as for the representation in this court.
The trial court actually dismissed the motion, the 3.850 motion?
Yes, as an unauthorized filing without prejudice for Mr. Melton to refile it was the way that the order was worded, and disqualified me from representing Mr. Melton due to the appointment on the capital case that's currently pending in front of the Florida Supreme Court as well as federal district court. It's a very complex case in the sense that Mr. Melton has a capital case. This case that we're here before you today was used as an aggravator in that case. CCRC initially had filed the original 3850 attacking this case to essentially get this case overturned and eliminated as an aggravator. Mr. Melton has a claim of actual innocence that we are trying to propound below in regards to this case. Obviously, that impacts the capital case and the weight of the aggravator or the very existence of the aggravator. Both this case and the capital case are also in the federal district court being held in abeyance while I had filed these successive 3850 in this case and the successive 3851 in the capital case. And so these cases are very, very intertwined. They're what I would say inextricably intertwined with each other because many of the players in both of the cases are the same and the co-defendants the same.
All these other proceedings you have mentioned, including the 2254 cases in federal court, are you counsel in all those other cases? Yes,
sir. I've represented Mr. Melton since I worked for Capital Collateral Regional Counsel here in Tallahassee in 2002, 2003 until it was defunded. Mr. Brett Strand and Judy Walker of that office had represented Mr. Melton prior to my being assigned the case. I had actually been hired to take Mr. Strand's spot. So,
is that in the record that you are 7 or 8 years into the case?
Yes, Judge. You will see that the motion for rehearing that was filed off of the original evidentiary hearing held in this cause, that was the first thing that I filed. I was employed at CCRC at that point in time. Subsequent to the denial of that, I had represented Mr. Melton before this court in his appeal from that. Through it was eventually PCA'd, and then after the PCA is when I went to the federal district court, filed the habeas petition, and was appointed to represent Mr. Melton in this same cause, stemming from this same cause by a judge, I believe it's in front of Judge Smoke in federal district court. So I've been continuously on Mr. Melton's case since 2002. As well, I've represented him in the capital case. The capital case was decided simultaneously in the trial court with this case. I proceeded to file in the Florida Supreme Court subsequent to the denial by a written opinion there. We went to federal district court. Both those cases were held in abeyance once I filed the successive 3850 in this case and the successive 3851 in the capital case. So it's got a pretty torturous procedural history as well as factually. It's I know we're not here on the merits, but it's it takes a pretty lengthy explanation to go through the facts as well.
Well, now, if you had remained an employee of the CCR, would you contend that you would still be eligible to represent Mr. Melton in this case?
Not pro bono, Your Honor. I would be disqualified from that under 27006 from doing it pro bono. I believe that the law of the case and waiver would still apply due to the quo warranto that had previously been filed, Butterworth versus Jennings et al., which Mr. Melton was a party to that and was represented by Brett Strand and the head of CCRC at that time, Michael Ryder. The court...
Why don't you start at the beginning and tell us about that case?
Okay. Your Honor, that was back whenever CCRC originally filed the original 3850 in this case. The Office of the Attorney General at that time moved and filed a quo warranto to prohibit CCRC from representing Mr. Melton in these proceedings, in this non-capital case.
There were other people involved?
It was filed.
It was just Mr. Melton?
No, sir. There was other people involved. It was brought. That's why Mr. Jennings was the head of the CCRC Middle. Mr. Dupree is head of CCRC South, and they had picked different cases that were applicable for each one of the regions. Mr. Melton being one of the ones for the northern region. So his case was specifically named within it as being via Michael Ryder and Brett Strand in their representation, because it was brought to prohibit their representation of Mr. Melton in this case.
All right, so he wasn't named, but his lawyer was.
His lawyer was, and it was specifically to prohibit them from representing Mr. Melton and other similarly situated clients. And this was ruled upon in the trial court, and it was denied. Then it went to the Florida Supreme Court. The Florida Supreme Court ultimately granted it in part and dismissed it in part without prejudice.
All right, so there was a motion in the trial court to disqualify.
A quo warranto action was filed.
In the trial court?
Yes. Then it went to the Florida Supreme Court after the denial. The Florida Supreme Court's ruling was that it granted it in part in that CCRC employees were prohibited from representing any of the named individuals pro bono because of Florida Statute 27.006.
And that's the statute that says, when you're talking about CCR, you're talking about state employees.
Exactly.
And the statute puts some restrictions on, puts some conditions on their employment.
Upon their state employment, that they cannot perform the pro bono hours. And
well, does it say that, or does it say that they can't engage in the practice of law? I'm not sure those are the same things, and I'm curious, how do CCRC lawyers discharge their Florida bar mandated pro bono obligation if the practice of law includes a prohibition against performing pro bono work?
My recollection when I was employed by CCRC, Your Honor, was that there's a specific box if you're a government employee that you checked that you're exempt from that. And I can't tell Your Honor whether it specifically says pro bono or the outside practice.
But you evidently, even though it would be against your interest to concede this, you evidently concede that 27706, where it says each capital collateral regional counsel and full-time assistant appointed by him or her shall serve on a full-time basis and may not engage in the private practice of law. You don't interpret that private practice of law to mean the business of law. You mean any case, including a pro bono case. Can't do any case.
That was my understanding, and the only reason I would concede that it applies here is because of the Butterworth versus Jennings and the ruling.
Let me ask you about that because I understand in this discussion that there's a difference, or you contend there are differences between registry counsel. I get that. We're just dealing with this a step at a time.
That's fine.
But in the Kilgore case, I didn't have a chance to study it. I did read it, but correct me if I'm wrong, but there wasn't really anything in that case that addressed this pro bono discussion that we're having now, was there?
I don't recall it specifically dealing with pro bono.
So the Florida Supreme Court has not really flatly said that a CCRC lawyer cannot do pro bono work.
I don't know that they've said you can't do pro bono work. I think in Kilgore they did mention 27006 that they were prohibited from representing Kilgore whatsoever.
But that case didn't concentrate and even discuss pro bono, is the point.
Yeah. Now, state lawyers sometimes, many state lawyers are not permitted to engage in private practice of law because it would be a conflict of interest. And because the state has a right to assure your full-time devotion to your job. But that doesn't mean that a state lawyer can't go down to legal aid and volunteer to do an eviction case. They do it every day. So I'm just having trouble understanding why everybody thinks that this prohibits pro bono work. But that's okay. Go ahead.
Well, and, Your Honor, it flatly doesn't prohibit me as a private counsel from doing that.
Well, I understand you have an argument that is a shade different here because registry counsel are not really employees of the state. You're just on a list, right? I mean, it's. I'm
on the list, and I sign a contract with the Department of Financial Services on a case-by-case basis. I have several of these cases. It's primarily what I do.
What do you make of? And I know you want to make this argument about law of the case, but let me ask you, what do you make of just jumping to the merits of it, what do you make of this sub 11 where it says a registry lawyer, says an attorney appointed under the registry statute may not represent the capital defendant during a retrial, a resentencing proceeding, a proceeding commenced under Chapter 940, a proceeding challenging a conviction or sentence other than the conviction and sentence of death for which the appointment was made, or any civil litigation other than habeas corpus proceedings. I mean, isn't that fairly direct? I mean, it's not hard to understand. It's not ambiguous to me. I mean, it says you can't do this.
But, Your Honor, I believe that only applies if I'm doing so at state expense.
But it doesn't say
where does
anything
it say
about
that,
state
though? Where does it say that?
27.7002, subsection 4, Your Honor, provides that no attorney may be appointed at state expense to represent any defendant in collateral proceedings unless as expressly authorized by Chapter 27.
So you assume that the legislature is talking about the same thing here in sub 11?
Yes, that is regarding state expense.
What if sub 11, though, just really reflects a policy decision of not, maybe people in the legislature were concerned that if you did this, that bills for one case would be improperly spilled over into bills for another. Maybe they were concerned that this would take too much of your time away from the thing that you agreed to do. Maybe there are other reasons other than payment of money that this pertains to. I mean, it doesn't on its face deal with payment of money.
I think only if you divorce it from 27.7002 sub 4, because I'm doing a pro bono. If I'm going to do a pro bono, then at that point in time, if they think that somehow I've committed fraud on my bill, that's a totally separate issue.
But if that's what the
it's
legislature
audited
meant,
and submitted to. I'm sorry, Judge.
I'm sorry to interrupt you. But if that's what the legislature meant, wouldn't the legislature have written sub 11 by saying the attorney appointed under 27.710 to represent a capital defendant will not receive compensation for representation in the other cases? I mean, if that was really their intention.
I suppose they could have written it that way, but I believe that when you look at 27.7002, they, in fact, did reference that it all deals with compensation, and it all deals with being compensated for the expenditures that you have regarding investigators and experts and those kinds of things.
11 says, just shall not represent the defendant in other cases.
Under your appointment. I've never specifically been appointed on this non-capital case. I represented him as part of the capital case. If I choose to, if this court rules that my argument regarding law of the case and waiver is not applicable here, I can still go back and represent him pro bono and just simply enter a notice of appearance, just as I would any other time that I discharge pro bono.
Well, you're saying you can, but doesn't 11 say that you can't?
I don't believe so, Your Honor, because of the 27.7002 sub 4, and that deals with if the state's footing the bill and the state's footing the bill for my services, then they can and I'm appointed.
What is the posture on that question? You made clear to the trial court that you were handling this pro bono. Didn't you handle something like this once before and succeed in getting paid over DFS objections?
I absolutely did, Judge. Whenever this was originally before this court and went back, the Department of Financial Services, through
Why
assistance...
did you decide to proceed pro bono in this case?
I haven't, Judge. I'm waiting to see how this court rules. I had filed...
So right now, you are not acting pro bono? You still intend to present a bill?
If this court rules that the law of the case and waiver applies, and that the motion to disqualify was erroneously granted, yes, I will seek compensation.
So if we overturn your disqualification, you will present a bill and ask to be paid?
Depending upon how this court rules. If it rules on the law of case and waiver favorably to my position, yes. If this court rules that I can do it pro bono, but I can't be compensated, then no, I wouldn't submit a bill, Your Honor.
You're under your 5 minutes if you want to say.
Thank you.
Good morning. May it please the Court, Charmaine Millsaps representing the state. First, I'd like to clarify Butterworth versus Jennings. Yes, the statute governing CCR does say the private practice of law. However, in Butterworth versus Jennings, this is what the Florida Supreme Court held. The petition is granted to the extent that attorneys employed by offices of collateral regional counsel are prohibited from representing capital inmates on other criminal cases on a pro bono basis. Understand that Florida Supreme Court in the Butterworth versus Jennings case went beyond the private practice of law and said, no, you may not do this on a pro bono basis. And
well, they interpreted the private practice of law to include.
Right.
Yes, they did. Now, Butterworth versus Jennings, that is not a published opinion, Your Honor. The language that I read from you is from the order on the Florida Supreme Court. You can see it on the docket. But that is an unpublished opinion. But understand that they granted the state's petition in Butterworth versus Jennings and said, no, CCR may not represent these people on a pro bono basis. And, Your Honor,
but now they were necessarily concerned about the expenditure of public funds because they're talking about the budget for the office and what employees could do.
Yes, Your Honor, but I think the legislature is equally concerned about registry counsel. Understand what happened in the initial proceedings here.
What is the rationale for this statute?
Well, I think obviously, Your Honor, the number one thing is it's a funding statute. The legislature wants to provide one round of post-conviction litigation and wants to pay for it. Understand that doesn't happen in most other states. Most other states, they have to do it all pro bono. We are one of the few states that has set up a publicly funded post-conviction litigation.
So you say the primary purpose is to limit the expenditure of public monies.
To one round. And understand something else, Your Honor. They are concerned about these bills getting tangled. That's exactly what happened the first time around in this case. He submitted bills on the non-capital case. These cases got all tangled together, and they are worried about running out of money. But the other thing they're concerned about, Your Honor, they really wanted one round of fair litigation and wanted to pay for that. Remember, this is a successive post-conviction motion. They are worried not only that they will get tangled in the initial thing, but they're worried that they're going to pay for more than one round. Understand, it's also...
But they won't pay for more than one round if counsel's doing it for free.
Well, Your Honor, that's not how he started. Understand where we started in the trial court. First he was going to bill for both his time and for investigative costs. I said no on that we objected to that. He then moved to no attorney's fees but costs. And I explained to Your Honor, we're not doing that either. And then he wanted to do pro bono. This is sort of a moving target. But understand, the state objects to pro bono, too.
Right,
there is another reason for all these statutes. That's to avoid delay.
Where are we procedurally? Is that issue squarely before us? I mean, is that the posture down there that, okay, I'll do it pro bono, and then the trial judge says, no, you won't, you're out of here?
In the end, yes, he did. Yes, he did. And I can read from the trial court's order. What he did was he struck. He uses the word struck. Hereby stricken as unauthorized. He then drops a footnote and says Melton can file this exact petition pro se. And what's more, Your Honor, if the trial court feels that this is complicated enough, he could, under the due process clause, maybe appoint another attorney. We don't even know that. Okay.
Well, I think the registry attorneys could make agreements with each other to do pro bono work for each other, couldn't they? I mean, because the way I read sub 11, it's only prohibits them from representing this defendant in another proceeding. Is that right?
Well, Your Honor, they might be
I'm
able
not
to.
suggesting further trouble here, but I'm just saying.
But understand, avoiding that kind of trouble is exactly why we have these limits. Okay? We're trying to avoid delay. I understand why CCR North was defunded. It's part of a pilot project. The legislature wants to pay for one full round of litigation and nothing more. We don't want successive motions.
The argument is, that argument is better for CCRC than it is for registry attorneys, because you could have, and I'm not saying this is the case, but you could have a registry attorney who just takes one case a year or something, and has plenty of time to do other pro bono work, and it doesn't infringe on the state's right. It doesn't impair the state's, the value the state got for its dollar. It doesn't get in the way of anything. Now, that's not reality. I realize these people are very busy, and they have lots of cases. But, I mean, the registry is a little different from CCRC. They're not full-time employees.
No, they are different that way. But understand, take Kilgore. Kilgore was dealing with CCR, but they went over in the registry statute and got that language. The Florida Supreme Court does not want to create a two-tier system here.
But they didn't say anything in Kilgore about pro bono work, did they? I mean, I read it hurriedly, but I didn't see anything in there about pro bono.
No, there's nothing in there. But what I'm trying to say to Your Honor is that even though they were dealing with CCR counsel, they looked at registry statute language to decide the case. And they do it the other way as well. And they do that for a reason. If you allow them to represent pro bono, then registry, then defendants on capital roll, on death row that have registry counsel are going to have people representing them pro bono in their aggravator, but CCR, death row inmates represented by CCR are not. You're going to create a two-tier system two ways.
Isn't the proper comparison, isn't the real baseline what the defendant with private means can do? Obviously, that defendant can retain a lawyer who can focus on the whole thing, pursue whatever collateral proceeding is indicated in the best interest of his client. And so, I mean, shouldn't that be the standard that you would want to make available across the board without regard to the circumstances of the financial circumstances of the defendant?
No, Your Honor, that's not even realistic. These inmates are represented by two sorts of people, registry and CCR. The number of cases I have, I've been doing this for a decade, the number of cases I have with true private lawyers where the family's paying for it, I don't need one hand to count those. Okay, so that's not realistic. That's not, the two-tier system here is going to be.
But in your view, it's all right for them to have an advantage, as few as they are.
Well, Your Honor, if they could pay, yes, they're going to be able to pay for successive litigation. Now, I think the Sixth Amendment issue that this court asked for supplemental brief on is not properly before this court.
All right, and I'd be very interested in your views on that. But let me ask you if I heard you correctly a moment ago when you said that one purpose of this statute is trying to avoid delay.
Yes.
Is that a legitimate reason to circumscribe the pool of lawyers that can be chosen from? Is that a legitimate reason to disqualify lawyers? Is their representation may be sufficiently vigorous and thorough that it takes longer than some other lawyer?
It is perfectly legitimate for the Florida legislature, and the Florida Supreme Court has said that too, that we do not want massive delays in capital cases. Your Honor, I'm not saying any of this
Well,
about the
I'm sure
initial...
and I understand that, and I don't think anybody does. Well, maybe I should not. Maybe I should qualify that. But the point is, there are legitimate ways to address delay, and there are ways that may not be legitimate. And one of the ways that may not be legitimate is to say, we don't want you to use the services of a lawyer who really knows what the case is about because he's been working on it for 8 years.
Well, but Your Honor, you're going to create a two-tier system. You are ignoring the fact that CCR cannot do this. There's no doubt that CCR cannot do this.
You're talking about a three-tier system, right?
No.
The very few privately retained lawyers, the CCR lawyers, and the registry lawyers.
Okay. Well, but the fact is, the vast majority of death row inmates are represented by CCR. There is no doubt CCR cannot do this. So what you're doing is it's going to be an inverse pyramid. The vast majority are represented by CCR. CCR may not do this. They may not file pro bono. They may not attack. That's the whole holding in Kilgore. CCR may not attack the underlying conviction used as an aggravator.
All right, now, I believe you indicated that if this proceeding is sufficiently complicated, that it falls in that category of collateral proceedings for which the cases say counsel should be appointed, that the trial court may well end up appointing a lawyer for Mr. Melton in this case.
The Florida Supreme Court, in a case called Graham, said the due process clause, not the Sixth Amendment right to counsel of choice, but the due process clause, if the case is complicated enough, as I'm sure this court is aware of the Graham decision, this court on occasion finds the case complicated enough, and the mere fact that it's used as an aggravator in a capital case, no, you should not have special counsel appointed.
Would that appointment violate 27-7-11?
Yes, Your Honor. Remember, my position here is the statute says you cannot do this. You may not file. You may not represent the defendant in anything but the case, the capital case for which you've been appointed.
The judge would have to appoint somebody else.
Yes.
And that person wouldn't be paid.
If in the rare case.
If it falls under Graham.
If it falls under due process in the rare case, it's not going to be automatic. It's not going to be close to automatic.
But in the event, a lawyer has to be appointed. The lawyer will be paid with public money.
Yes, Your Honor, if it's complicated enough, but not automatically.
The lawyer would have to expend more time, presumably, beginning at square one, familiarizing himself or herself with the case.
Oh, Your Honor, I don't. The claim is a newly discovered evidence claim. That's going to be, they're going to be able to get up on speed in that. This is not a appeal of 12 issues. This is a one claim, newly discovered evidence claim. So if you're saying that would be inefficient, I don't. I think any counsel appointed in the due process clause, if he's appointed, not just automatically because this is used, that's the other way you're creating a two-tier system. Understand something. The vast majority of non-capital defendants do not have a lawyer in post-conviction. They proceed pro se. And what you're going to be doing here is creating a tier where if it's used as an aggravator, in other words, if you kill again, you get a lawyer in your non-capital case. But if you don't kill again, you don't get one. Now, that's another way this is an uneven system. Your Honor, obviously, if a judge...
That's only if some lawyer wants to appear pro bono. And by the way, there are quite a few lawyers in the bar, and somebody else might want to appear pro bono. So then this again, offends your sense of justice that somebody has a lawyer. I mean, it's just, in one sense, it's a... Your argument is that you're not saying, or are you, that they can't have a lawyer. You're just saying, and it doesn't cost the public a penny. You're just saying it can't be the lawyer who knows most about the case.
That's what I'm saying, the latter. Of course, due process, the Sixth Amendment does not apply to post-conviction. So Sixth Amendment right to counsel of choice doesn't apply.
So
The due process clause
there is
would-
no right to counsel
in post-conviction, no, counsel of choice.
Right to counsel means a couple of things. One thing it means is the right to have a lawyer represent you if you can pay for it.
And that does not apply in post-conviction. Now, due process.
You do not have the right for a lawyer to appear
No
if you can
United
pay
States
for
Supreme
it.
Court has ever extended their Sixth Amendment right to counsel
That
of
is the
choice.
state's position,
Yes, Your Honor.
that the state could require people to appear pro se even if they could afford to retain a lawyer?
I said under the Sixth Amendment. Under due process, I think under the state constitution, the exact analysis that they used in Graham would, under the state due process clause, allow you to bring a lawyer that you were willing to pay for. But it's not Sixth Amendment. It's going to be a state-based.
The point is,
and incidentally, we've never raised
if a
any of
defendant
this.
hired a lawyer, that lawyer would be able to file post-conviction motions.
Yes, Your Honor, but under the due process clause.
Well, under whatever, the defendant would be able to file 3.85 and 3.851 motions.
Yes, he
But
can
no, let's
hire.
say it's not under Graham.
It's a Graham-like analysis. I think they're going to.
Let's say that under the Graham factors, it doesn't qualify. The state could forbid a defendant, the move-in, the convict, to retain private counsel who would appear on his behalf.
No, Your Honor, I think the state due process clause, just like it did in the Graham, would be used as an analogy for the Sixth Amendment right to counsel, and you could bring counsel. If you're willing to pay counsel, you can. It's not a Sixth Amendment. That matters, Your Honor.
Okay, but all right, so I misunderstood earlier because I maybe I got too excited here. I thought you were saying that a person could not retain a lawyer to represent him in a 3.850 proceeding unless the Graham factors were present.
No, Your Honor, I think.
You're saying that you would concede in any case, any move-in under 3.850 has the right to be represented by counsel if he can retain counsel.
Under the state due process clause, yes.
You can't
Under
qualify it.
this,
Just answer the question.
yes.
If a
No,
convict hired a
I
lawyer,
need to-
well, if a convict hired a lawyer to represent him or
Yes.
her in post-conviction,
Yes.
the state couldn't object to that.
No, Your Honor.
Okay.
But that's not a Sixth Amendment.
I know, but
We
just-
did.
I just need to
Okay.
ask that question.
Okay. Okay.
Those cases that, I mean, I understand what you're saying, that the defendant does not have a right to a court-appointed counsel in a post-conviction proceeding. The U.S. Supreme Court decided that, and the Florida Supreme Court has followed that, and that's an accepted principle. I think the U.S. Supreme Court said, except in unusual circumstances, would that be the case. But you're talking on the one hand about the right to appointed counsel and comparing that somehow with the right to be represented by counsel. And that's a different thing. I mean, you're not saying, are you, that a defendant has no right to bring a lawyer or the right to. So if you look at this from not the standpoint of what is the state's obligation to provide appointed counsel, I'm with you on that. I'm totally with you on that. But here's where I'm losing you. Are you saying that the defendant doesn't have a right to choose his own lawyer if he can pay or if the lawyer is willing to go pro bono?
No, Your Honor. Yes, he may. But the yes comes from the state due process clause, not the federal Sixth Amendment right. The answer is yes.
Okay, wherever it comes from then, if we look at this case now, we're analyzing the defendant's right, not his right to be paid. This doesn't have anything to do with him. The defendant's right. If we take your position that he can't do this case pro bono, are we violating the defendant's right to select his own counsel?
And that's what I wrote the supplemental brief on. And that's where I say the Sixth Amendment, and that's why it matters whether it's a due process analysis or a Sixth Amendment right to counsel of choice. Remember, there's the Sixth Amendment right to counsel when the state must provide one. And then a Sixth Amendment right to counsel of choice, which is when the defendant is willing to pay for him or the lawyer is willing to appear pro bono. Now, I think that issue is not properly before this Court, because while I wrote a brief, opposing counsel did not. Okay? So this Court, neither I nor this Court put things at issue. The Sixth Amendment right to counsel of choice has not been raised here. He did not file a brief. I don't think it's properly before this court. But I'd like to go further and answer your question.
I think I understand you. You're saying essentially that you understand there is a difference between the defendant's right to choose counsel and the right to have a court-supplied or appointed counsel, and you're saying the Sixth Amendment doesn't protect either one of those things in a post-conviction proceeding.
Yes, Your Honor, that's exactly what I'm saying.
I will study this more carefully if it is an issue, and I respect your point that you say it's not, because he didn't raise this, and so your point on that is the court's question invites a decision on this case on a point that was not raised.
Yes, Your Honor.
Okay. I understand your argument.
Okay. But I do want to...
I thought that your brief, in fact, let me see if I can find the passage. I thought you said in your brief, the denial of the right to counsel of choice is structural error, which is equivalent to fundamental error. Preservation of such a claim is not required.
That's true. That's the holding in Gonzalez, and that structural error is very equivalent to Florida's fundamental error. But, Your Honor, it's not before this court, whether it's fundamental error, structural error or not. He did not raise it. You cannot raise these claims, and he hasn't even raised it at oral argument.
You're saying he didn't raise it here.
He didn't raise it here.
If he didn't preserve it, we would be able to consider it under the fundamental error exception to the preservation of...
Yes, if he had included it in his initial brief or...
Not raising it here is fatal in your view.
Yes,
okay.
Your Honor. Yes, he must have raised it, Your Honor, this court, and I thought it was very generous and a much better way to do things when this court has a problem, to ask us to brief it. But he chose not to. Fundamental error is not something that courts sua sponte raise, appellate courts. He did not raise this below, but I agree, it's not, preservation is not required.
So this case is not about, as far as you're concerned, the convict's right to retain an attorney, whether he pays for it or it's pro bono.
No, I don't think this case is about that. Okay? I don't think this case, but more importantly, the Sixth Amendment is something that has simply not been raised here.
All right, now the trial court, you say that in the trial court it was clear and the trial judge well understood that he was proposing to go forward pro bono, and the trial court ruled no, I'm striking the motion, you cannot proceed pro bono.
Yes, Your Honor. That was a moving target, but that's where we ended up. We
ended up.
started with payment, and then we started with attorney's fees and costs, and then it was just costs.
But the order being appealed is the order that he's talking about, the order on appeal.
Yes, Your Honor, it was stricken. The underlying motion was stricken.
All right, so the ruling was no, you cannot appear pro bono on behalf of this person. There's no question. And so now he has no lawyer. And you're generously saying, well, he can proceed pro se.
Well, the trial court said that, Your Honor.
All right.
Capital counsel is hereby
that.
prohibited from representing the defendant on the instant case. I'm reading directly from the trial court's order. That's what he said. Okay? And then he said he struck the motion, and...
I'm not sure striking the motion is the right remedy, are you? I mean, there are cases where if a lawyer is not authorized, for example, a lawyer who is a foreign lawyer who doesn't have permission to practice in Florida files a pleading, the pleading is, for purposes of the time for filing it, I mean, it is all held in place. The lawyer is removed, but the pleading is not stricken. I mean, that is...
I agree with that, Your Honor.
So let me explain. I'm only worried about this defendant, some trial judge saying, oops, you blew your 2-year time period now, sorry. I just don't think that's the right remedy.
I agree with all that, Your Honor. Let me explain why I asked him to strike this. There's another thing that's bubbling up here. This is a successive motion. When he started, I got this as registry counsel filing this. That's where we started. Okay? Registry counsel is not allowed to file successive motions. That's why I wanted the underlying pleading struck. I agree with you, Your Honor. Normally, if it was just a question about the attorney should be removed and the pleading should stay in place. But the reason I didn't want the pleading to stay in place was successive motion by registry counsel. The motion itself is unauthorized, statutorily unauthorized. So I asked for both remedies, and I think in this case, because of the prohibition on registry counsel filing successive motions, it was proper to do both.
Well, what about the point that the 2 years may run?
Your Honor, if this weren't unauthorized, I think I thought I answered that. I agree if it's untimely. First of all, Your Honor, this is a newly discovered evidence claim. So in this particular case, timeliness doesn't matter. Timeliness is off the table. State's not, I don't ever do time bars on newly discovered evidence. So, but in some other
There's no requirement to file within 2 years of the newly discovered evidence.
Well, I think you could also argue that you were litigating this, that it would file. Your Honor, I'm not going to do this based on timeliness. I can tell you that right now. But let's talk about another case where timeliness would matter. Normally, if it's just removing the lawyer, it would be improper if you asked me for the state to then say that was untimely, to even ask for it to be stricken. I asked for it to be stricken based on the prohibition of successive motions. That's a whole separate thing that has also not been raised here, Your Honor. So, you know, we're going way beyond any of the briefs with a lot of the issues here. I pointed that out to the court in my supplemental brief.
But you are saying that his status as a registry lawyer was an impermissible basis to strike the motion?
No, Your Honor, he started that way. He's not allowed when he is registered. He started as registry counsel wanting to be paid. And so I responded as registry counsel wanting to be paid. Okay? And so my motion was both to remove him from the case and strike it.
Then he shifted ground on you and said I'll do the pro bono.
Yes, Your Honor. And that came up in the hearing on my motion.
Okay,
so it moved from registry being paid both for his attorney time and costs to costs only to then pro bono.
But it was in that posture when the trial court ruled.
Yes, Your Honor. We did end up there. I'm just explaining why I thought.
Are you telling us that the proper remedy would have been to disqualify counsel, not to strike the motion in those circumstances?
If it didn't have the issue of registry counsel being, no, I think he should have stricken this. We're saying he is unauthorized. He may not file this. And I did want to remember the bills here did get tangled up in the initial one. And how important that is we have a limited amount of funds. If they're going to exceed the scope here, we are going to run out of funds for registry counsel representing capital defendants on their initial post-conviction motion.
Well, but that's
we
not
can't
the
pay
issue
for
here
this.
when counsel's trying to appear pro bono.
Well, one of the concerns here is that the bills get tangled up. And that's not a theoretical concern.
That's a separate issue to me.
I'm just telling you that in fact happened in this case with the initial one.
You've gone way over. We're going to give
Okay, all right. Thank you very much. We ask you that you affirm the trial court.
We're going to give you another 6 minutes, hoping you don't use it.
Well, there's so many things I want to address at this point in rebuttal. Number one.
Well, I want to know about this point about, well, isn't that a legitimate basis for this statute, that we don't want to have to pick through on the billing? It's going to be a nightmare. We don't know what pertained to the last collateral attack here. We don't know what pertains to the capital case.
That's not how it worked. The way it worked is I submitted my bill to the Department of Financial Services, who has assistant general counsel and a contract manager. I distinguished what I did for this case as opposed to what I did for the capital case. We went before, and they objected on the basis that I shouldn't get paid on the non-capital case. They never objected to the reasonableness of the hours. They conceded that They had no objection whatsoever as to whether I did the work, whether it was reasonable or anything like that. We went before Judge Skavatsky, who had that case at that time. Judge Skavatsky heard it. He ordered that I be paid on that. I was. The Department of Financial Services, nor the Attorney General's office, or anybody ever appealed that. They could have appealed that, and which is so much what when I'm talking about the law of the case and waiver, that plays into it. They chose not to pursue anything. So then, years later, after I found the 7th, 8th, and 9th witness to say the co-defendants testified untruthfully in this case, because that's what we're talking about, just to give a little perspective. We're talking about the 7th, 8th, and 9th witnesses to come forward to say Tony Houston and Ben Lewis were not telling the truth whenever they came forward in court, and that they made a deal to save their own selves. And so that's what we're talking about. And so when I came back and filed it again, I had every expectation that I would be paid because I've been paid before. That's the way this case had worked. They had brought the issue twice before. They had been unsuccessful twice before. But I told the judge, I said, Judge, if you do rule against me, just know I've got so much invested in this case, I'm willing to keep going. And I would do it even if I wasn't being paid. So yeah, it's a fallback position, but to characterize it as a moving target, that's not a moving target. What it is an expectation based upon rulings that were in the case before. And I still maintain that under the law of the case in waiver, that I should be able to proceed and be paid.
It's a separate how is it law of the case?
I don't believe it's a separate proceeding, Your Honor, because when we looked at in 3850C, we have, as criminal defense lawyers on behalf of our client, the state regularly imposes waiver on us in the sense of we have to show that could it have been brought before? Was it appealed before? If it hasn't, we waive the ability to do it. Yet they don't want that to apply to them. A perfect illustration is here today of arguing that, well, I didn't brief the Sixth Amendment right of counsel, so I waived it. The state doesn't.
How about that? What do you say to that?
The way this
is that presented?
That was presented by this court that said I could file a brief or I could be prepared to address it here today, and I was prepared to address it here today. It gave the option. I thought that the Gonzalez case was pretty clear. It was a Sixth Amendment right to counsel. I disagree with the state only to the extent that I don't think the U.S. Supreme Court has ruled that post-conviction counsel is not authorized under the Sixth Amendment. I know that definitively the Florida Supreme Court has said that there is no right to post-conviction counsel in the appointed sense. Anybody that wants to hire somebody can, or if they have someone that's willing to represent them pro bono, they can, either way. Because to say that he could represent himself pro se, this is an individual that this case happened when he was 17 years old. That was 19 years ago. He's been on death row for 19 years. He never finished high school. He has no ability to represent himself. He authorized the filing when he verified on the oath down at the bottom. He authorized me to file that and said that he agreed with the facts that were in there. So it's not anything that he can pursue.
But you presented this case to us not as a case about whether or not the defendant can retain counsel, but as a case about whether you can represent counsel pro bono.
I framed it within the confines of what the state had raised. It was never an issue. I filed it with the full expectation that it was an authorized filing based on what had been ruled before. The state raised the issue relative to the statute and me being disqualified regarding the statute. So I addressed my arguments as to whether or not the statute applied to me or not. That's why I went with the law of the case and waiver arguments that were presented in the briefs, and alternatively told the court if I was incorrect and the court ruled against me, I would still proceed pro bono and fully think that it's authorized for me to do so.
Up here, in your brief, do you say my client has the right to my representation if I proceed pro bono?
Not that succinctly as what Your Honor just said, but I say that I'm authorized to do so pro bono because the statute doesn't prohibit me from doing so.
So I mean, she's saying fundamental error, she's okay with that, but you've got to speak up, and that you never presented the issue. How do you respond to that?
I presented the issue because I filed it. I argued that I should be on the case, whether it be paid or pro bono.
In the appeal. She's saying that in the appeal, the issue was not raised.
Well, they waived the issue. It's there. I'm authorized to practice before this court. Have my client's approval.
No, I'm sorry. No, in the appeal, the question is whether in the appeal you raised the issue that your client's rights were violated by the court's refusal below to allow you to proceed on his behalf pro bono.
Not as directly as what Your Honor is stating. I guess maybe I assumed it in the sense that it's unfathomable to me that my client wouldn't have the right to have an attorney in post-conviction proceedings if that attorney is willing to come forward. I don't know. Maybe it's my own blind spot. It's just being unfathomable that someone has an attorney that's ready, willing, and able, and knows the case as well as I know the case.
And your whole statement of the issue is all this law of the case and waiver stuff.
And actually, you don't get to the issue you're talking about today until page 40. There's really, I guess it's just page 40 and 41 that you talk about it.
That's true, Judge. I was more responding to the court's interest rather than speaking to my own interest. My own interest is that you rule that it's the law of the case because Judge Skavatsky ruled that the quo warranto was not well taken, and they never further pursued the remedy after being dismissed in the Florida Supreme Court, and that they waived it.
The Florida Supreme Court dismissed the quo warranto proceeding as it pertains to registry counsel. Is that right?
It was CCRC counsel at the time.
Right.
And they dismissed it as to without prejudice. The only part that was granted was that the CCRC counsel could not represent them pro bono.
Well, how is it that the dismissal of an extraordinary writ proceeding, the dismissal, not a decision, in your view, becomes a binding decision on the merits of an issue for subsequent?
The binding issue, and this is where the interplay between the waiver and the law of the case goes, is that Judge Skavatsky had ruled in the defendant's favor that Mr. Strand and Mr. Ryder could continue to represent him. Then it went to the Florida Supreme Court. They dismissed without prejudice. So then the evidentiary hearings held with Mr. Strand and Mr. Ryder representing him. I take the case because I replaced Mr. Strand. And then the court rules after I've become a registry attorney and been appointed as registry counsel, and I appeal both of them to this court and the Florida Supreme Court. Subsequent to that appeal is then when the Department of Financial Services, through their Assistant General Counsel, objects. Judge Skavatsky rules that I'm entitled to get paid on the case. They never appeal that whatsoever. So you have two instances where the trial court decided that it was authorized for me to be able to continue to represent Mr. Melton in the first DCA. The state never pursued their remedies. It was only this last time that they began to pursue their remedies, and the trial court below agreed with them, and thus we're here. So they've had ample opportunity. This is a very involved case over a very lengthy amount of time. And as far as another attorney being appointed, that attorney, it's not just it's easy to say it's just a newly discovered evidence claim, but you're talking about numerous witnesses involved, recantations as far as to these witnesses that we've brought forward, and to say that you can only present it kind of in a over here discreetly, that's not the case. You have to understand both cases.
It's not a wise decision of the legislature. The legislature has authority to set set limits on the attorneys.
And they did, as to if I'm getting paid by the legislature or not. Mm-hmm. And that's why, alternatively, I'm saying that I'll do it pro bono. It was before Kilgore that all of this prior happened, And they had been making the same argument that was made in Kilgore. Eventually, the Florida Supreme Court took the issue directly and decided Kilgore. So when
I think we have your position.
okay, thank you.
Thank you, and thank you both.